Yes, good evening to everybody. Welcome to the Law of Thought class. And yesterday I dealt the Reliance versus Fletcher 5 to 6 exceptions. But in this class, let me see the absolute liability. Then read what I posted on the screen. Yes, read what I posted on the screen. No personal talk, please.
Absolute liability law. Principle of absolute liability. In the fundamental principle of law that no, sir, it's not very clear, sir.
Okay,
It's not
okay.
clear.
That
Please
is
zoom
not
it, sir.
visible to you. Okay, now is it visible?
Yes, sir.
Yes, read.
Principles of absolute liability. It is a fundamental principle of law that sic utera tuo ut alienum non ledis means enjoy your own property in such a manner as not to injure another persons. But there are certain occasions and activities by which there are chances of causing harm or injury to the useful peoples, for example, factories.
The principle of absolute liability, yes, you can enjoy whatever you want in your property in your own place, but your enjoyment should not injure the your neighbor, another person. So the legal maxim is sic utere tuo at alima alinam na ledas, means the equivalent English is enjoy your own property in such a manner as not to injure another person's. But there are certain occasions and activities by which there are chances of the causing harm or injury to the useful people, for example, factories. The factories are very much useful for the production and to raise the GDP of a country, and many people will be employed over there. Then, if there is any harm is caused over there, like the pollution, then can you stop establishing the factories? Yes. Answer. Answer.
Yes, sir. Yes.
If you stop establishing the factories, there would not be any employment at all. There would not be any competition in the world. No, you can establish the factory, but see that you should be try to minimize the pollution. So to minimize the pollution control board will says grow the plants, grow the bushes, grow the garden, and see the it will be suppose the toxic substances are there. You neutralize it before you are sending out to the outside. So these are the things that you have to make it out. Then minimum thing should be the harm should be caused to the flora and fauna and aquatic animals also. So that is the reason that we will make it out. Now let us see that what the concept of absolute liability. Then when you say the absolute liability, the first and foremost case law comes is MC Mehta versus Union of India. That is also known as oleum gas leak case or Sri Ram Fertilizers Limited, like which are shown here. Sri Ram Food and Fertilizers gas leak case. This is MC Mehta versus Union of India case law. So in this case law, and the principle of strict liability, but with no exceptions were given, and the individual is made absolutely liable for this act. It is based on the principle that the defendant, can you write the want like this? What is this want? In abbreviation, what is the want in the abbreviation? భక్తులారా నిద్రపోయినరా అండి.
Contraction.
It is a contraction. Why you are taking that much time? When you are writing, you never write like that in your article, in your answer. You can use that only in SMS language. Okay, that is a style of writing. The defendant would not be allowed to plead the defense if he were accused she was at fault as it was laid down. So the Leland versus Fletcher case law, we have taken the how many exceptions? How many exceptions? How many exceptions?
Pass on, sir.
There is, see, I repeated 3 times, but you are not giving the answer to me. How many exceptions?
6.
6 exceptions. What are they? సార్ నాకు తెలుసు సార్ మీరు అడుగుతారని నేను ఒకటి చెప్పినా కదా సార్ అయిపోయింది నాకు పని సో లెట్ యూ ఆస్క్ ద అదర్ పర్సన్ వాట్ ఆర్ దే need not to say in the sequence we can start with anyway middle to the lower to the upper to the lower what are they సార్ కట్టె గౌర తాంబాలము వడ్డాలము these are the exceptions we discussed yesterday in your sir yesterday I was not present sir but you might have heard my at least video sir I did not heard your video sir I did not watch because there is a net problem sir anyone at least say one
Statutory authority.
after crying at least 1 minute then slowly coming the answer yesterday
Contributory negligence. Act of God or vis major.
plaintiff the wrongdoer
Yes, sir.
mutual benefit consent so those are the 6 exceptions are there in the Reliance versus Fletcher after the Bhopal gas leak case. What is the Bhopal gas leak case? What is the name of the case law? What is the name of the case law? Rendu sarla. What is the name of the case law? Mudu sarla. Union Carbide versus Union of India. I told several times, but still you did not catch me. Bhaktulara unnara andi?
Yes, sir.
But why you are keeping quiet? This is the way you have to remember the things. Read, recite, review. Otherwise, you will not know anything. So, what is the name of the Bhopal case? Leak case law?
Union Carbide versus Union of India.
What is another name for the Bhopal gas leak case law? Pass on చెప్పరాదండి మేడం మీకు ఇచ్చాను కదా వరం
Pass on, sir. Pass on.
why you are taking such much time if you don't know say pass on I will give the answer why you are killing my time మీకు ఒక వరం ఇచ్చాను కదండి నేను రామబాణం ఇచ్చాను కదా మీకు పాస్ అని అనండి అని మిక్ ఎంఐసి మిక్ కేస్ లా వాట్ ఈస్ మిక్ isocyanide. So, how many names are there? Bhopal gas tragedy case law, MIC case law, and Union Carbide versus Union of India case law. So, here I literally I went to the Bhopal one time because of I want to face an interview in the National Law School as their teaching staff over there. But anyway, I was not selected because they said you are not up to the mark. I said thank you very much, sir, because I'm already working there at the time, the University of Dar es Salaam. Okay, now let us come to the point. I saw the people still, there are around the factory. I went to the factory also just to see. It became a desert. Still, there are people are there, those who suffered and lame and eyes lost, crippled. Still, they are staying over there. But they are getting the every month, what I say, some type of stipend because they deposited a lot of amount. So they are getting as a pension like that. So they are still leading the life in the same surrounding areas. And some of them, they become a crippled also. The pregnant women also there, they get miscarried. So some of them I had a touch with them. But anyway, that what I want to say is, it is a world shaken. And the world knows what is Bhopal. And world knows what is MIC. And world knows absolute liability. The absolute liability concept in the tort law, the India is the pioneering. MC Mehta is the first case law, oleum gas case law, where the absolute liability is sprouted, germinated, but it will come to the limelight through the Bhopal gas tragedy case law. So there are many people are there, those who suffered over there. And these Bhopal gas agitators, they say we follow the strict liability rules to certain extent, the elements, but we don't follow its exceptions. The rule laid down by the Honorable Supreme Court of India is much wider with respect to the rule laid down in the House of Lords in the case of Reliance versus Fletcher. This is the style, the old style of writing versus this is the new style of writing. Full stop should be there, and it should be italics. It should be italics.
Italics.
Yes, it's
Italics.
enough. When italics is enough, you need not to highlight it. But in the writing, just you can change the color of the ink. Suppose you are writing the blue ink, you write with the black ink enough. Sir, I want to use the red ink. Don't use the red ink. Don't use the green ink. Only two ink colors are allowed. What are they?
Blue and black.
Very good. I appreciate. అంటే భక్తులు నిద్రపోతలేరు అన్నట్టు అర్థం నాకు. Okay. It was propounded by the Supreme Court that where an enterprise is engaged in a hazardous or inherently dangerous activity, and if any harm results to anybody on account of the accident in operation, the enterprise would be held strictly and absolutely liable to compensate to all those who are affected by the accident. But if you happen to see in the Rayland versus Fletcher, it is not that much big enterprise, but it's a small one. It is lost to the persons. But here when you come, it comes to the enterprise, which is in a large quantity or a big in returns and big the things are concerned. So let me see some of the ingredient. As you said, the essential elements of the absolute liability, the same thing should come over there. The dangerous thing. What is the dangerous things? What are the things dangerous?
Fire.
Explosive materials.
See, here I put it on the screen. If you happen to see,
Water.
also you could say.
Water, gas, electricity, vibration, savage,
If you
explosives.
just have a close look at also, you can give the answer to my question. It's the water which is in a high quantity, bulky quantity, the water body, and the gases, electricity, vibrations, sewage, flagpole, explosives, noxious fumes, rusty wires, etc. ఆ ఫెన్సింగ్ వైర్ నేను చెప్పాను చూడండి, ఏం వైర్ అంటారండి దాన్ని?
Pass on, sir.
పాసానా?
Yes, sir.
బార్బుడ్ వైర్ అన్నా కదండి. ఇక్కడ యూజ్ చేశాను కేసులో అది a western toilet, and she used it by passing through the electric wire which is live, but while it's coming she was touched it, then she was electrocuted and died on the spot. What is the name of the case law?
Pass on, sir.
Cherivan Grigari versus State of Bihar. సార్ కరెక్టేనా సార్? మరి కోస్తానరా, చెక్ చేసుకోవాలా, ఎందుకంటే ఎప్పుడైనా మంచిదే. చెరూబియన్ గ్రిగారీ వర్సెస్ స్టేట్ ఆఫ్ బీహారేనా వేరేదా? ఎస్, చెరూబియన్ గ్రిగారీ వర్సెస్ స్టేట్ ఆఫ్ బీహార్ ఉందా అండి?
Yes, sir.
ఎస్ సార్. చెప్పాలా నాకు తందానే తారానే వరకు నేను ముందుగా ఐ కెనాట్ గో ఫర్దర్. ఓకే, సే yes.
Okay, sir.
Very good, very
Yes, sir.
very good, very good. I appreciate. So even the electricity, if you keep it over there, Cherubim and Grigari versus state of Bihar, that is the private defense, the amount of the force which is used is more than required over there. Hence, the defense of the private defense is not applicable over there in the defenses. ఈ విధంగా గుర్తుపెట్టుకోవాలి. This is the method where we have to remember the things. I am showing the technique also to you. Okay, good. So now dangerous things are, these are all things are dangerous things. Okay, now escape. Anything which has caused damage or insult, mischief should have escaped from the area which was under the control of the defendant to come under the ambit of the absolute liability. Parameter, ambit, under the umbrella, vicinity, ఇవన్నీ నానార్థాలే. In the ambit of the absolute liability, like it happened in the The Reed versus Leans and Company, where the plaintiff was working as an employee in the defendant company, which was engaged in the manufacturing the shells. The shells means bombs, gelatin sticks, explosive materials. The accident happened when there was on a duty that day within the company premises only. It happened when a piece of which was being manufactured was exploded, and due to which the plaintiff suffered harm. But the defense taken by the defendant that there is no escape because it is the premises is happened over there. Hence, it comes under the exception because it did not escape. But yesterday I have told one case law. It is not escaped. The horse intruded in the plaintiff's garden and nibbled the leaves of a tree. What is the name of the case law? What is the name of the case law?
Sorry, sir. Pass on.
Noak versus Pontiff. Is it correct? Say Pontiff versus Noak or Noak versus Pontiff? Let me check is Noak versus Pontiff or Pontiff versus Noak or another name. Ponting versus Noakes. What is the name of the case law?
Ponting versus Noakes.
కొత్తగా నేను ఏం చెప్పాను అక్కడ ఒక పదము. What is the
Nibbles.
new
Nibbling.
word?
Nibbles.
Nibbling.
Nibbles అన్నాను నేను.
Nibbles.
Nibbles.
The defendant fence ate some leaves అన్నారు ఇక్కడ. ఇక సరిగా మీ నిబుల్స్ లేకుండా కనీసం ఏట్ అన్న వేసేయండి. కానీ నిబుల్స్ అన్నారు అనుకోండి, ఎగ్జామినర్ లైక్ మీ, he feel more happy, he will give the good marks to you. Are you following me? Say yes.
Yes, sir.
Yes, sir.
Okay, sir.
I appreciate. So that is the Ponting versus no case law. There is no escape because the horse itself is the intruder. Here the explosive case law, explosive is exploded when they are testing it, but it's not escaped over there. Then say they could not escape the word, they could use it. But when the matter comes to the absolute liability, there is no necessity that he should escape. If any person, the employee got injured, it doesn't go beyond the premises of the factory, it doesn't matter. It once comes out of, which is hazardous in nature, hence the absolute liability would be there. There is no question of any escape. So this was declared by the court because of the explosion that took place was within the defendant's premises, not outside. And the concept says that it should have escaped the dangerous thing like a shell here from the boundaries of the defendant premises, which did not happen, was not missing over there. So the negligence on the part of the defendant could not be proved in that court. But in the case of the absolute liability, there is no necessity. If anything comes out in the same premises and where the people are working, even they died, it's tantamount to escape because it escaped from the container. Are you following me?
Yes, sir.
Not from the premises. So that is the meaning we have to take into the ఒక కేసులో ఉన్నదండి. I don't know whether you could, when you read the Smith versus Huck కేసులో అది, it comes in the interpretational statutes. ఆ కేసులలో ఏమంటారంటే ప్రాస్టిట్యూట్స్ ఉంటారు కదా. What is another name for the prostitutes?
Pass on, sir.
Harlot. 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 Or whore. 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 Harlot. 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 These harlot whores are standing on the street and they are enticing, luring the customers for the BBC, the body-to-body contact, for their trade business, flesh business. So in the England, they passed the Street Offences Act. There the section says, if any harlot or whore standing on the street and enticing, luring and inviting, making gestures to the customer for the sex, they will be liable under the offense of prostitution. So this what the whores they did know, the harlot, they're standing in the balcony of their own house, and of those who are passing, and they are luring from there by showing some of the body parts, or they are making the signs to them to lure them. So The state filed a case against this horse. You are enticing, luring, and inviting the customer for the sex. But they say, we are not standing on the road. We are standing in our balcony. We are standing in our house. We are standing in our window. So the court said, mischief's rule. This is a mischief rule. You will come across it. Not literary meaning you should take. Not golden meaning you have to take. The mischief he has made it over there. What is the intention of the parliamentarian? Not to lure. Either you are standing on the road or you are standing in your balcony. Am I right?
Yes, sir.
So they say, still you are come under
Yes,
the
sir.
offense. So you are lured it. Either you standing on the road or standing in the balcony or through the window. If you make them to gestures, make them to show their your parts, or calling them, or clapping them, or inviting them, it's amount to the enticing, luring, even though you stand in your own house. So when you come across the international interpretation of the statutes, you could remember the Smith versus Hutchins law, where the mischief rule would be there. So here also mischief is there. See, to make the person liable under the principle, the plaintiff is first needs to show that the defendant had done for non-natural use of land and escaped the dangerous thing. So if anything you collected in a bulky, then it becomes a non-natural of land. See, you are having only your husband and wife, don't have the children, even no issues are there. Can you keep the 20,000 liters what a tank on your roof?
No, sir. No, sir.
Merely waste, because it is not for the use. It is no, sir, for 1 month, sir. Even 1 month, why do you use such a water? Daily fill it, daily use it. So here, Charing Cross Electrical Company versus Hydraulic Power, the defendant was assigned a supply of water for the industrial works, but he was unable to keep their main charged with the minimum pressure that was required, with the led to the bursting of the pipeline at the different places. Suppose when the heavy water would be there, pressure would be there, your pipeline gauge should be the thick and the valve should be the strong one. If the pressure is more, the valves are not strong, it will burst. The result in the causing the heavy damage to the plaintiff, which was proved in the court of law, the defendant was held liable in spite of they were not at fault. There are the few rules of which our doctrine is applied over there. So if the mischief is there, means you have to see that what is the intention of the parliamentarian, what is meant by escape. Escape not from the premises, escape from the container, it is enough. Are you following me?
Yes, sir.
Good, good.
Yes, sir.
The scope of the rule of absolute liability, what they said is, yes, please read this one. Anyone can unmute and read this much area.
In most of the places, the rule of strict liability and absolute liability are seen as exceptions in the law, and the individual is held liable only when he or she is at fault. But in such cases, the individual could be held guilty even if he is not at fault. After the catastrophic accident of Oleum gas leak the Act of the Public Liability Insurance Act 1991 was introduced. With the main purpose.
Yes, enough. What I highlighted, that much is enough. See, if it is escape from the container, it amount to the escape. Not necessarily should escape from the premises. So what they did it? The government? No. All the people, those who are working under such a hazardous industry, they should be insured. That is the reason they passed the Public Liability Insurance Act of 1991. All the employees should be insured in the hazardous industry. So insurance company, of course, they will come to the rescue at least. Otherwise, the company will not pay that much expenses. So the distribution of the risk to the insurance company. Of course, we have to pay the premium also, depending upon the amount which you fixed it. So they are introduced with the main purpose of the providing the immediate relief to the people who are victim of the accident in which handling the hazardous substance is involved. At least they will get something in the form of compensation immediately from the insurance company, if it is so. Of course, limited again. If you make it more, you will get the more, but the premium is high. I told you one, I don't know whether you could remember it. An expert who is good in the mathematics, well versed in the statistics, and well versed in the economic theories, and who fixes the premium of the insurance is called పాస్ అని చెప్పేసేయండి, ఎందుకో మీకు వేస్ట్ చేస్తారు టైం. అది
Pass
Pass
on,
on,
sir.
sir.
Actuary. Actuary. Again, I will show you because I will use this word. What is the person? A person who is an expert in mathematics and statistics and financial management to fix the premium. చదవండి ఇప్పుడు చదవండి.
A person who compiles and analysis statistics and use them to calculate insurance risks and premiums is called as actuary.
Yes. What is the role of actuary? ఇక్కడ కనబడతలేదా అండి? ఇక్కడ కనబడతలేదా మీకు?
To use math for statistics.
The actuary uses the maths and statistics to estimate the financial impact of the certainty and help clients to minimize the risk with the median salary or the so and so. And this person who is fixing the premium is called
Actuary.
actuary antaru. Okay. So in the premium that is fixed by the actuaries and they are expert in the mathematics and statistics and financial management. That is the people. Mali, sorry, I don't want to lead to the another point. So any hazardous substance would be there when you are working naturally that you will be insured. So that is another point. The term handling is described in the section 2, class C of the Public Liability Insurance Act 1991. నేను ఇక్కడ సబ్సెక్షన్ సి అనలేదు. ఎందుకు అనలేదండి? If you know it, you tell me. If you don't know, say pass on.
Pass on, sir.
See, when you read the section, please note the point. The first section should be the Arabic numeral. Section 2, generally, never small c, never small Roman will come in subsection. Then what comes? Again, Arabic numeral. Or capital A, capital B, but it is not a subsection. It is adjacent to the section which is added over there. When it is a capital. When you come to section 2, I did not say subsection C. I said section 2 class C, because generally in every statute, section 2 is definitions. And these definitions are independent. I will show you also if you want. And the definitions are independent. But when you come to the law of contract, section 3 is the explanatory interpretation clause, means nothing but definition clause. So if you happen to see this Public Liability Act, I will show you section 2 subsection C. They will say the reason is, see, 2 is a definition. Did you see it? Did you see
Yes,
it?
sir.
Yes, sir.
And C is a handling. Here, handling. అయితే దీనికి ఏంటంటే సూత్రం ఏంటంటే, in this act, unless the context otherwise requires, a little tag is there, tail is there. When there is a tail is there for the section heading and the explanation, when the small a is there, b is there, they are all independent, not related to one another. Check it. Accident, independent. Collector, independent. Handling, independent. Whether the handling is having any connection with the collector?
No, sir.
So that is the reason we will say the clause. A clause never have the connection with the another, but a subsection is having the connection with the another. Either above one or the below one or the main section. So that is the difference of reading. If you miss my class, you miss many things. I told you, this is the one of the thing.
Yes, sir.
నాకు అవసరం లేదు చెప్పడానికి, but I don't want. I want my students like Professor Hussain, because replica of Professor Hussain, that's my intention. Replica అంటే తెలుసా అండి?
మరో రూపం లాగా, సార్.
Shadow.
As it is.
Shadow.
రెప్లికా అంటే షాడో. సిల్హుట్టే అంటే కూడా షాడో. సిల్హుట్టే. సార్ మీరు దండం పెడతా సార్, కొత్త కొత్త పదాలు యూజ్ చేయకండి సార్. ఎప్పుడు తెలుసుకుంటారండి? వెన్ డూ యూ నో ఇట్? షాడో, రెప్లికా. Our Indian tort law is nothing but the replica of common law. Our contract is nothing but the replica of English Contract Acts. Our law of evidence is nothing but replica of English law of evidence. Of course, here and there changes according to the prevailing situation in India. Justice, equity, and good conscience. That is the blanket principle. So now, the Public Insurance Act 1991, which is a clear expression of the rule of the absolute liability, laid down the MC Mehta versus Union of India. So strict liability, absolute liability, the same thing? No. Strict liability, absolute liability, not the same thing and are different. As in strict liability, the defendant has a chance to escape the liability after the causing the damage and injuring various. Under the absolute liability, there is not the case as the defendant held absolutely liable for his acts, because in the strict liability there are exceptions. In the absolute liability, no exceptions. In strict liability, there are some defenses which are available to the wrongdoer, but in absolute liability, there is no defenses available and given to the defendant. Acknowledging the need to modify the 19th century rule of the strict liability, as the apex court of the MC Mehta versus Union of India stated that, moreover, that the principle which was established in the Reliance versus Fletcher case cannot be applied in the modern world. Cannot be applied in the modern world, because the rule was laid down in the old world as compared to the own laid down in the modern world. సార్ ఇప్పుడు బెల్బాటంలో దొరుకుతారా సార్?
No, sir.
నేరో పాయింట్లు దొరుకుతున్నారా సార్?
No, sir.
Rarely, sir.
ఆడోళ్ళు మాత్రం చుడిదార్ పైజామా దొరుకుతాను. No, better they use the loose pants. It's more good than the using such a way. It's nothing but in one way, in another way, luring. Okay, let us come to the next point.
Luring.
The main aim is to limit the scope of the rule and bring it at the same level of the modern society. So absolute and strict liability exceptions already we read and seen it. And the first public interest litigation, మనది ఏ కేసులో డీల్ చేసిందండి? పిల్ పబ్లిక్ ఇంట్రెస్ట్ లిటిగేషన్ ఇండియాలో.
Pass on, sir.
హుస్సేన్ ఆరా ఖాతూన్ వర్సెస్ స్టేట్ ఆఫ్ బీహార్. హుస్సేన్ ఆరా ఖాతూన్ అనే కేసులా ఉన్నది. ద ప్రిజనర్స్, they are ill treating over there. So one of the fellow file a case on behalf of all the prisoners, and the Hussain Ara Khatun versus state of Bihar. I think state of Bihar is right, or malli evana gadbad vachinda? So far my knowledge.
Yes, sir. State of BR 1979.
Yes. So that is a very famous case law. That the first PIL case law. So now Bhopal caste tragedy case law is a very famous case law, because by that absolute liability has emerged over there. And ఒకటి బాండెడ్ లేబర్ కేసులా ఉన్నదండి. ఇది ఫేమస్ కేసులా. బంధు ముక్తి మోర్చా వర్సెస్ యూనియన్ ఆఫ్ ఇండియా. దర్ ఈస్ దెన్ ద పర్మనెంట్ కతారా వర్సెస్ యూనియన్ ఆఫ్ ఇండియా. దే ఆర్ ఆల్సో ఆర్టికల్ 32 to the Supreme Court, under article 226 to the High Court. One can go for the PIL. Of course, we can CRPC provision also can be used over there for getting the PIL. So MC Mehta case, Union of India, I already told you that it is a public interest litigation made with MC Mehta and the Sriram Food and Fertilizer Industries, and the gas, oleum gas leakage was there, and where the many people are died, and one of the person who is an advocate of the Tisazari court, he died, and many were injured over there, and that is the reason the MC Mehta filed a case, and the PIL pill. And the judges in this case refused to follow the strict liability principle set up by the English law and came up with the doctrine of absolute liability. They overruled the strict liability rule, because it is having the exceptions 5 to 6, and they said the absolute liability. The court then directed the organization who had filed the petition to file a suit against the industry in appropriate courts within the span of 2 months to demand the compensation. Bhopal gas tragedy, that is also Union Carbide Corporation versus Union of India 1991, MIC poisonous case law, and with this absolute liability is highlighted with the Bhopal gas tragedy. But it is sprouted స్ప్రౌటెడ్ అంటే తెలుసా అండి?
Germinated, sir.
Germinate అంటారు దాన్ని. Germinate. When it's sprouted, sproutling will come, sapling will come. So that is the sapling from the MC Mehta versus Union of India, and it is come to the limelight through the Union Carbide Corporation versus Union of India, which will shaken the entire world, and the jurisprudence of the law of tort has bring to the light. It is we are the pioneers to make the concept of the absolute liability. So now the government of India enacted the Bhopal gas tragedy process of the Claim Act 1985. The Union of India is filed, then later on the oral, it is the settlement is the best judgment. Settlement aindi. Okay, this much we will going to pay you for this one. Now you do it. So now all the amount is taken by the government of India and deposited in the respective victims' name in the bank, and they will get the interest and they will eat it. They will survive it. So another case law is the Indian Council for the Enviro Legal Action versus the Union of India. This is also a bill was filed under Article 32, and where the villagers were endangered with the vicinity of the industries, especially tanning industries. Tanning industry అంటే ఏంటిదండి?
Pass on, sir.
Leather industry, చర్మం industry. They will make the leather soft by using the chemicals over there, and that the toxic substance will be comes out of the factories, tanning industries, and ఎల్బీ నగర్లో కూడా ఉండే tanning industry, అటు దేశపేటలో కూడా ఉండే చాలా, but now they are completely closed tanning because now they don't have any market value now. The even skin of the either goat or sheep or cow or buffalo or anything. So absolute liability can also upheld by the court in the case of the single death without any mass destruction of the property or pollution. Not necessarily should be mass death would be there for the absolute liability. Even a single death also be there. It is enough. The absolute liability would be applicable. Then absolute liability in certain cases, this class meter chart, East India Hotel Limited, the case law once I repaired. This is the co-pilot German. What is the German Airways? ఒకసారి మీకు ఫోటోలు ట్యాగ్ ఫోటో తెచ్చి పెట్టాను నేను. జర్మన్ ఎయిర్వేస్, లుఫ్తాన్సా.
Lufthansa. Sorry, sir. గుర్తొస్తలేదు.
సో ద జర్మన్ ఎలైట్ ఏంటంటే వీళ్ళకు అవర్ల బేసిస్ మీద ఉంటుంది. వీళ్ళకు ఒక 8 hours 10 hours నడిపింది అనుకోండి, దే విల్ నీడ్ ద 24 hours రెస్ట్, again or 48 hours rest. Then all the thing will be provided by the Lufthansa. So Lufthansa had the East India Hotels Limited in the 5-star hotel. So in this there is a swimming pool. There is a swimming pool. These are all diving boards అన్నట్టు. Height ఉంటుంది 1 2 3 4. When you are diving from the fourth, the upper part, then the depth of the water depth is more. Are you following me?
Yes, sir.
Because of
Yes, sir.
గ్రావిటేషనల్ ఆ ఫోర్స్ మీద పడితే
Gravitational.
లోపలి కిందికి పోతాం కదండి.
Yes, sir. Yes, sir.
They should maintain the what is the depth of the water. If the depth of the
Water
water
level.
తక్కువ ఉన్నదనుకోండి, ఈ మీదికెళ్ళి కొడితే ఏమవుతుందండి, తలకాయ డైరెక్ట్ గా it will touch to the bottom of the swimming pool, and so the German pilot they did not use it. The water level is not proper, and he dived from there, and he became directly hit the head. Then his backbone, he became a tetraplegic. The 14th bone was a bit crashed, and he became a tetraplegic, and he was there lived for the 14 years, and much compensation they got it because the insurance company is there and these people paid and all those things. Well, the case is pending, that fellow died. So in this case law, what they say, there is absolute liability would be there on the hoteliers for maintaining the
Low level of depth water in swimming pool.
pool. And they will not allow them to go up when the depth of the water is less. And they do not allow it. They have to lock it. Here they lock it the doors, so nobody would go upside. Only this much from there they can dive it. If the depth of the water is not much. So depending on the depth of the water, and this thing will be there. When they jump from there, naturally they will fall here. When they jump from there, here they fall here. So the depth is more here and the depth is less here. Are you following me?
Yes, sir, we are following.
So
Yes.
Sir,
absolute liability would be there in the East India Company, and they do not take any other thing because you are the occupier and you should take the lot of care for this one because you are paying the lot. The 5-star hotel charges to you, and this also case law again I refer in the actio personalis maritime cum persona. A personal right of action dies with the person. There also use this class metal Bachat versus East India Hotels Limited. ఇట్లా రాస్తారా అండి ఏఆర్? కెన్ యూ రైట్ ద ఏఆర్ ఇన్ దిస్ వే?
No, sir. You should write them together without points.
You remove the full stop and AR need not be italics. The citation need not be in italics. What should be in italics? Only the name of the case law.
Case
Title of the
law.
case law should be in italics. No citation. Citation should not be italics. But citation should not come here. It should come in the footnote. It should come in the footnote. And the AR, All India report, what is the abbreviation? What is the abbreviation?
Initialism. Initialism.
ఇంతసేపా అండి? ఇమీడియట్గా చెప్పేశారా? బిఫోర్ ఐ ఫినిష్ మై వర్డ్. 1997 Delhi and AR All India Reporter 1997 year is the Delhi decision and the 201 సింగిల్ జడ్జ్ చెప్పాను. 201 ఎట్లా రాస్తారండి? TWO2
NOT not
pass on, sir.
ONE1.
నేను దాన్నే పెడతా చెప్పిన మీకు. ఎనోటి నాట్ కాదు అది. NAUGHT. What is that?
NAUGH.
Or another meaning NOUGHT. Both are acceptable. Not. Only one. That is the way of Professor Hussain student should know. Not ki KNOT not rayadu, NOT not rayadu. NAUGHT or NOUGHT, not one. So that is the style of Professor Hussain. So this case law will come across. Please remember the name of the case law. Class Mr. Metal Bachard versus East India Hotels Limited, Delhi case law. And let us see what is the distinction between the two. Sir, it is not visible. Don't worry, I will magnify it so that it will be visible to you. Yes. So now let us see that what is the difference between the strict liability and absolute liability. Read number 1.
Strict liability. The nature and quantum of damages.
Yeah.
The nature and quantum of damages that are payable to the plaintiffs are compensatory in nature. That is, in accordance to the amount of loss suffered by the plaintiff, damages will be paid equivalent to the amount lost.
Yes. Equivalent damage only paid over there. Next. Right.
Absolute liability. The nature and quantum of damages that are payable to the plaintiffs are exemplary. The compensation provided to each aggrieved party is much greater in amount. That is, the damages paid are more, as in such cases people lose their lives and environmental conditions become life-threatening.
The damages paid in the absolute liability are exemplary, but here the damages paid in the strict liability is only compensatory. Exemplary means at least 2 times, 3 times more than the actual damage. That is exemplary damages. Number 2.
The defendants can take the help of several defenses like the following: damage caused due to natural use of land, consent to the plaintiff, plaintiff's own default, act of stranger, act of God or his measure, common benefit of the plaintiff and the defendant, statutory authority. If any of the
Such a
defendants
thing would be there in absolute liability.
No, sir, absolutely not.
No, that's why there is a blank. Here,
Yes,
what is
sir.
number 3?
If any of the defenses apply to a particular case correctly as decided by the preceding judge, then the defendant will not be held liable.
Generally, it will not be. But in this case, it is an absolute liability put upon the defendant where the scope of any defense being taken is allowed. They are the held liable
Not
for the
allowed.
payment of. Here,
Not
they are,
allowed.
of course, here the point is no. You take any defense, it's not allowed. I don't know why he said in this case it is an absolute liability put upon the defendant where the scope of any defense being taken is not allowed. Yes, not allowed. Sir, నేను కాదు సార్, act of God, not allowed. Sir, నేను పడేయలేదు సార్, మా కొడుకు పడేసిండు, not allowed. Are you following me? So these are
Yes,
the
sir.
things where I want to make it out, the distinction between the strict liability and the absolute liability. కానీ కొన్ని చోట్ల చూస్తే రిజర్వాయర్ ఎవడు కట్టిండంటే ఫ్లెచర్ కట్టిండని చెప్తాను. ఏం చెప్తాను, అందులో
Silence,
ఉన్నది. రిజర్వాయర్ ఎవడు కట్టిండ్రా అంటే ఫ్లెచర్ కట్టిండంటాడు.
Ryland.
ఫ్లెచర్ ఎక్కడ కట్టిండ్రా అంటే నేను ఇప్పుడు ఇందాక చూశాను, నేను మీకు కూడా వినబెట్టిస్తాగండి. హౌ కుడ్ యూ సే దట్ ఫ్లెచర్ హ్యాస్ కన్స్ట్రక్టెడ్ ద రిజర్వాయర్? బికాస్ ఐ సా it is the...
Yes, sir. In recently, I too found same thing.
I said how it could be. So better we will run the show with the defendant and plaintiff rather than the writing who is who. We are least bothered about who constructed it. We are more bothered about there is a strict liability would be there. See here, when I saw this one and that fellow is saying it is Fletcher. వినబడుతుందా అండి మీకు? వినబడుతుందా?
మీరు మాట్లాడేది వినబడుతుంది సార్.
No, sir.
ఎందుకంటే నేను కొంచెం ఇక్కడ గారడి చేయాలి ఇప్పుడు. దీనికి ఈ గారడి చేసేప్పుడు వినబడుతుంది, లేకుంటే వినబడదు. ఇప్పుడు గారడి చెప్తాను నాకండి, ఇప్పుడు వినబడుతుంది.
Cover damages. If a defendant hasn't been negligent, the injured plaintiff usually can't.
Yes, sir. వినబడుతుంది సార్.
For certain types of danger, the law has developed the principle of strict liability. Under this doctrine, certain harmful acts can merit compensation even if the defendant didn't act negligently. The British case of Rylands versus Fletcher considers one situation in which strict liability applied. In 1860, Rylands owned a mill in Lancaster County, England. They wanted to build a reservoir to supply the mill with running water, so they hired an engineer and other contractors. The engineer then selected the reservoir's location, designed it, and built it. But long before the reservoir went up, the site had been mined for coal. Decades, perhaps centuries earlier, 5 vertical shafts had been dug, then later filled with soil, rocks, and timber. By the time Rylands came along, these ancient shafts were completely hidden and long forgotten. Rylands' engineer discovered the shafts during the reservoir's construction, but didn't warn Rylands the reservoir and began to fill it with water. Fletcher operated coal mines on land adjacent to Rylands' mill and reservoir. Fletcher's mines connected to various underground caves and crevices, and eventually to the ancient shafts now underneath Rylands Reservoir. In December, as the reservoir was being
Yeah, it is the Indian tradition that in the beginning or the ending of any program that we will make the play of the national anthem. Now the national anthem will be...
विंध्य हिमाचल यमुना जहां से अच्छा हिंदुस्तान हमारा। जय हिंद।
जय हिंद।